Did you know that judges don't actually make laws? That's right. The real law-making power belongs to the legislature, the folks we elect to write the rules we live by. Judges step in after the fact. Their main job? To interpret those laws and make sure they're applied fairly and consistently. But here's where it gets interesting. In modern times, judges have been handed what's called discretionary powers. That means they're not just reading laws literally. They get to interpret the words and meanings, deciding what lawmakers actually intended. While this flexibility can help when the law is unclear, it also leaves a lot of room for abuse. Sometimes this has led to decisions that seem more about generating revenue than delivering true justice, making everyday actions feel like commercial transactions. Let's talk about writs. Other than habeas corpus, most writs you hear about are what's called extraordinary writs. They're emergency legal orders, sort of a last resort when there's no other remedy, like an appeal available. For example, the writ of prohibition can stop a lower court from stepping outside its bounds. Mandamus can force a public official or judge to do their actual job. Quo warranto, that's what you use to challenge whether someone even has the right to hold public office in the first place. But here's a little known fact. Most of these writs except habeas corpus don't even go by their old names anymore. The Writ of Mandamus, for example, is now just called a mandatory order. This isn't just a name change, it's a power shift. With those new titles, these legal tools have become weaker and less accessible. So, what kinds of writs are we really talking about? Let's break down a few. First, habeas corpus. If someone's being detained unlawfully, this brings them before the court. Mandamus, that's used to force a public official or court to do their duty. Certiorari is when a higher court wants to review a lower court's decision. Prohibition prevents a lower court from going outside its jurisdiction. Quo warranto challenges someone's right to hold public office. Some other lesser-known writs include Coram Nobis, which helps fix fundamental errors in a criminal case, and Procedendo, which tells a lower court to get moving if they're dragging their feet. There's also the Writ of Inquiry, used to figure out damages after a default judgment. Inhibition, to stop a judge from moving forward in a case. And execution, which lets law enforcement seize property after a judgment. Understanding these writs and how judges use and sometimes misuse their powers can help you see how our legal system really works. So next time you hear about a court order, you'll know exactly what's at play behind the scenes. Prerogative writs. Writs issued at the discretion of the sovereign or state, e.g. habeas corpus mandamus. Prerogative writs are extraordinary, discretionary court orders used to compel or restrain government officials, agencies, or lower courts, ensuring they act within the law. Originating from English law as powers of the crown, these extraordinary remedies act as a safety net when no other appellate remedy exists. Discretionary power. Unlike standard lawsuits, the court is not required to issue these. It has the discretion to refuse. Unlike appeals, many writs are discretionary, meaning the court decides whether to accept the case based on factors like legal error or major public interest. Extraordinary remedy. Often, they are only granted when standard legal appeals or procedures are unavailable. Writs are typically used when standard legal remedies like direct appeal are unavailable or inadequate. Remedies used when no other adequate relief is available, e.g. prohibition, certiorari. Extraordinary writs are discretionary, non-routine legal remedies filed directly in appellate courts to address immediate, irreparable errors when no adequate ordinary appeal exists. These, such as habeas corpus or mandamus, are governed by strict procedural rules and are not rights, but rather exceptional measures for urgent situations. Initiation. Unlike appeals, writs are often initiated by filing a petition directly with the appellate court. Judicial review. They serve as a primary mechanism for reviewing administrative and quasi-judicial actions, as explained in this Florida Bar Journal article. These writs are essentially designed to ensure that government entities and lower courts act within their legal authority. Judicial writs, writs issued during a lawsuit, e.g., Writ of Inquiry. A judicial writ is a formal written court order commanding a person or entity to perform or cease a specific action. These powerful legal instruments, often rooted in common law, provide extraordinary relief when standard appeals are inadequate, acting as direct commands from higher courts to lower courts, officials, or individuals. No other remedy. Writs are generally only issued when there is no plain, speedy, or adequate remedy in the ordinary course of law. Discretionary. Issuance is at the court's discretion rather than being a matter of right. Speed is critical. They are often subject to strict time limitations, such as within 60 days of a ruling, to be effective. Original proceedings. Writs are initiated by filing a petition directly in the appellate court. 4. Stopping abuse of jurisdiction, preventing lower courts from violating legal boundaries, enforcing duties, forcing officials to act, protecting rights, protecting constitutional or legal rights when urgent action is required. Nominis, lies for someone wrongly imprisoned for another person with the same name. De-Identitate Nominis, sometimes De-Identitate Nominis, is a Latin legal term translating to of identity of name or of identical name. It is a specific type of ancient legal writ designed to protect individuals from wrongful detention or seizure of goods due to having the same name as another person, often referred to as identity theft by namesake. This writ lies for a person who has been arrested or whose goods have been seized under a capias, a warrant for arrest, or exigent, a process to declare someone an outlaw, that was actually intended for a different individual with the same name. Sheriff, issued to the sheriff to inquire whether the person held is the same individual named in the action, and if not, to discharge them. Escheator, directed to the escheator if the person's goods are mistakenly seized. Legal mechanism. It serves as a remedy against the wrongful harassment or imprisonment of an innocent person due to mistaken identity. Modern equivalence. In modern practice, this type of issue is typically handled through a habeas corpus petition or procedural motions regarding identity. Error nominis translates to error of name, referring to a mistake or inaccuracy in a person's name in legal documents. De-Identitate Nominis, an alternative spelling of the same writ. Ingressu, a writ of entry for recovering land. A writ of entry is an archaic legal instrument used to demand a repossession of land unlawfully occupied by another, acting as a real action to recover possession from a dispossessor. In modern context, it is primarily used in certain jurisdictions as a foreclosure method, allowing mortgage lenders to reclaim property after a borrower defaults. Letters, patent, close, historical instruments for land grants or royal commands. Letters patent and letters close represent two distinct types of historical legal instruments issued by a sovereign, king, queen, president, that differ primarily in their intended audience, sealing, and publicity. Letters patent are open letters designed for public view, granting exclusive rights, privileges, titles, or offices to individuals or entities. For more on common law writs, see this article from the Florida Bar. For specific legal applications in Florida, see this trial attorney guide. A writ of habeas corpus is a foundational legal order requiring a detaining authority, e.g., prison warden, government agent, to produce a prisoner and legally justify their confinement before a court. It acts as a crucial safeguard against arbitrary detention, allowing individuals to contest unlawful imprisonment. Latin for "you have the body." It is a civil action, not a criminal appeal, brought against the government to contest detention. It guarantees that a person can be brought before a judge to determine if their detention is lawful, covering arrests, prison sentences, and immigration detention. Protected by the U.S. Constitution, Article 1, Section 9, which mandates that the privilege of the writ cannot be suspended except in cases of rebellion or invasion. Federal habeas corpus, 28 U.S.C. Certiorari 2254. allows federal courts to review state court convictions if they violate federal law. Limitations, AEDPA of 1996. The Anti-Terrorism and Effective Death Penalty Act imposed strict limits, a 1-year statute of limitations, restricted successive petitions, and required that the state court's decision was contrary to or an unreasonable application of federal law. Used when a prisoner believes their conviction violates the Constitution. In immigration cases to challenge detention or deportation, or to bring a person into court for testimony. The petition, often called a complaint or motion, must name the custodian, the person restraining the individual. If the court finds the detention unconstitutional or illegal, it can order the individual's immediate release. Historically, the writ has only been suspended during extreme circumstances, such as the U.S. Civil War. A writ of mandamus is an extraordinary court order directing a government official, agency, or lower court to perform a mandatory, non-discretionary ministerial duty they have failed to act upon. It acts as a final resort to compel action rather than to influence how a decision is made. To compel public officials, lower courts, or corporations to perform legal obligations, generally only granted when no other adequate legal remedy exists. It can only force an official to act if they have a legal duty to do so and no discretion. It cannot force a specific outcome for a discretionary decision, e.g., it can make an agency make a decision but not force them to approve a permit. Orders the defendant to perform the action or appear to explain why they haven't. An absolute final order instructing the immediate execution of a duty used to monitor a lower authority's compliance over time. When can it be used? Lower court inaction. A judge refuses to rule on a motion. A government agency like USCIS fails to act on a request within a reasonable time. Compelling the release of documents after a request is ignored, forcing an official to fulfill a duty required by their position. You must prove the following by clear and convincing evidence. The petitioner has a specific legal right to the relief requested. The respondent has a mandatory duty to perform the act. No other adequate conventional legal remedy is available. It must be shown that the delay is unreasonable. A petition is filed in a higher court, e.g. the federal district court or court of appeals, against the officer or lower court. The court may order a response or deny it immediately. It is not a substitute for an appeal. The Supreme Court and lower federal courts are authorized to issue these writs. A right of prohibition is an extraordinary discretionary legal order issued by a superior court to a lower court, tribunal, or public officer, commanding them to stop proceedings that exceed their lawful jurisdiction. Known as a drastic remedy, it is used to prevent the unauthorized exercise of judicial power rather than to correct errors. It stops a lower court from acting without jurisdiction or exceeding its authority, challenging a judge's denial of a motion to disqualify themselves due to bias, stopping prosecutions where the statute of limitations has expired, preventing double jeopardy, addressing situations where a tribunal attempts to hear a case that is not under its jurisdiction. The applicant must show the lower court is acting without jurisdiction and that no other adequate, efficient remedy, such as an appeal, is available. It is often considered the counterpart to a writ of mandamus. Generally, a petition is filed in a higher court, e.g., Court of Appeals, outlining the legal reasons for the request, as discussed in the Florida Bar Journal article. Alternative writ directs the lower court to stop acting or show cause why they should not be prohibited from continuing, according to Wikipedia. Peremptory writ, a final order that absolutely commands the lower body to stop proceedings, as described in Wikipedia. Prohibition versus injunction. Prohibition is directed at a court or tribunal, while an injunction is typically directed at individuals. Prohibition versus mandamus. Prohibition stops a court from doing something. Mandamus orders a court to do something it is legally required to do. Writ requirements can vary by jurisdiction. The above is a general overview based on common law and specific court rules, such as those provided by the U.S. Court of Appeals for the Fourth Circuit. A writ of certiorari is an order by a higher court, usually the U.S. Supreme Court, directing a lower court to send up a case record for review. It is a discretionary appeal, not a right, with the Supreme Court accepting only about 100 to 150 of the 7,000 plus petitions filed annually. To review decisions from federal courts of appeals or state Supreme Courts, generally focusing on significant legal questions, constitutional issues, or resolving conflicting decisions among circuit courts. The rule of four: at least 4 of the 9 Supreme Court justices must vote to grant the petition to hear the case. A petitioner files a petition, and the respondent has 30 days to file an opposition brief. The case usually involves significant federal questions, conflicts between circuits, or serious departures from accepted judicial procedures. Denial of the writ does not suggest the high court agrees with the lower court. It simply means the case will not be reviewed. The petitioner submits a request for review. The respondent files an opposing brief, and the petitioner may reply. Justices review the petition in conference. The court either grants, accepts, or denies, rejects the petition. For more, refer to the official Supreme Court procedures from the U.S. courts and detailed explanations on the certiorari process. A quo warranto writ is a legal order used to challenge a person's right to hold a public or corporate office, or to question an entity's authority to exercise specific powers, meaning by what warrant or authority in Latin it compels the holder to prove their legal right to that position or power, preventing the unlawful usurpation of office. It is an extraordinary remedy aimed at testing if an office holder is lawfully and constitutionally authorized to perform their duties. Public office challenges. It is commonly used to remove individuals unlawfully holding positions like council members, school board members, or directors. Corporate franchise authority. A state can use this writ to revoke a corporation's charter or challenge its authority to exercise specific powers. It is often initiated by a state attorney general, though in some cases a private citizen with standing can petition the court. It has been used to challenge a governor's authority to call a special session, test a municipality's right to exist, or challenge a prosecutor's authority. Synonyms and related terms of warrant of authority. Information in the nature of quo warranto, commonly used synonym in legal proceedings. Action against usurpation of office. Right to office challenge. This writ acts to ensure that public authority is not exercised without legal authorization, focusing entirely on the legality of the office holder's title, not their performance. Writ of error coram nobis, used to correct fundamental errors of fact not apparent in the original record that, if known, would have prevented the conviction. A writ of error coram nobis is an extraordinary post-conviction remedy used to ask a court to correct its own judgment based on a fundamental, previously unknown error of fact, not law. It is used when this new fact, if known at trial, would have prevented the conviction, and it is usually filed when no other remedies like appeals are available. It functions as a motion to vacate a judgment due to errors that were not in the official trial record. Examples include proving a guilty plea was coerced, the defendant was insane or a minor without a guardian, or key evidence was wrongly withheld by the prosecution. The petitioner must show the error was not due to their negligence, it was unknown at the time of trial, and it is vital for justice. Often used by petitioners who are no longer in custody but face collateral consequences, e.g., immigration issues. A motion to vacate judgment is often used interchangeably. It is technically a form of a writ of error, coram nobis versus coram vobis. Coram nobis, before us, is filed in the trial court that rendered the judgment, while coram vobis, before you, is issued by an appellate court to a lower court. Factual error versus legal error. It is used only for errors of fact, not for challenging legal errors made during the trial. It is not meant to be a substitute for a direct appeal, and it is generally only granted in rare scenarios where a miscarriage of justice would occur otherwise. A writ of procedendo is an extraordinary, high-level legal order issued by a superior court, usually an appellate court, to an inferior court, typically a trial court, commanding the lower court to move forward and render a judgment in a case. It is specifically designed to combat unreasonable, unlawful delays in legal proceedings. Its sole purpose is to order a lower court to stop stalling and issue a decision. No dictation of outcome. The writ does not tell the lower court how to rule, only that it must rule. Remedy for delay, used when a court fails to act, ensuring justice is not denied through inaction. Historically, it is one of the prerogative writs intended to check the inaction of lower courts. Proves clear right. To succeed, the petitioner must prove they have a clear legal right to a prompt decision. E.g., a motion has sat pending for an excessive, unjustified amount of time. The writ cannot be used to force a specific ruling on a substantive issue, only to break a procedural deadlock. Writ of Procedendo versus Writ of Mandamus. While often filed together or confused, they have different nuances. Procedendo specifically commands a court to proceed to judgment. Mandamus, a broader, more common writ used to compel a lower court or government official to perform a duty they are obligated to do, which could include issuing a decision but also acting on other non-discretionary duties. A judge has not issued a final decision or ruling on a case, motion for months or years after it was submitted. Post-conviction petitions. A court has not ruled on a habeas corpus petition or motion for post-conviction relief in a criminal case. Family law. A judge fails to issue a divorce decree within mandated time limits, e.g., in Ohio, 90 days. If the lower court fails to comply with the writ of procedendo, the judges involved may be held in contempt of court. It cannot be used for direct appeals to overturn a ruling. It cannot be used to rush a case that is legitimately complex and requires more time. It is not the proper tool to challenge unlawful imprisonment. That requires a writ of habeas corpus. A writ of inquiry is a civil court order issued after a default judgment, commanding a sheriff or judge to hold a hearing and determine unliquidated damages owed to a plaintiff. It occurs when liability is established, but the specific monetary amount is unknown or disputed. The primary purpose is to assess damages to aid the court in finalizing a judgment. It is used only after a default judgment, when a defendant fails to respond, and in cases where damages are not predetermined, unliquidated. The clerk of court issues the writ to a sheriff. The sheriff summons a jury to hold a trial, often called an inquisition, to determine the damages. Although traditionally done by a sheriff, the inquiry can occur in court with a judge presiding. The sheriff returns the findings to the court. It serves to inform the conscience of the court. Writ versus fact sheet. In Florida, if a judgment is entered, a fact information sheet, Forms 1.977 or 7.343, may be ordered to assist in collecting on the judgment. The Florida Rules of Civil Procedure specify rules regarding default judgments, which can lead to a writ of inquiry. Alternative definition. A writ itself is a written legal directive from a court to take specific action. A writ of inhibition is a legal order, typically issued by a higher court to a lower court, acting as a preventive remedy to halt unauthorized actions, stop improper jurisdiction, or prevent a judge from proceeding in a pending case. It acts as a strict check to prevent abuse of judicial power and is distinct from an appeal. Key aspects of a writ of prohibition, inhibition. It is a proactive, drastic remedy designed to stop proceedings before the unlawful action occurs. It is not a matter of right, but a discretionary tool used by superior courts, like a Supreme Court, to restrain inferior tribunals when a lower court acts outside its legal jurisdiction. If a trial judge improperly refuses to disqualify themselves, to halt litigation against defendants who are immune from lawsuits, it cannot be used to correct past errors, which is the purpose of an appeal. Effect: once issued, the lower court must immediately cease all related proceedings. Scottish inhibition, property debt. In Scottish law, a separate concept of inhibition exists. This is a personal diligence used by creditors to prevent a debtor from selling or encumbering their heritable property, like a house or land, during a court action to secure a debt. These inhibitions last 5 years. A formal petition, a comprehensive brief, must be filed in the appellate court. The judge or lower tribunal is considered a formal party in the body of the petition, but is often omitted from the caption. Order to show cause. If the petition has merit, the court issues a show cause order, which acts as a stay of the lower court's proceedings. If the problematic act has already taken place, this writ is inappropriate. Instead, an appeal or other post-judgment remedies must be used. For those looking for official documentation or templates, they can use legal templates available through resources like U.S. legal forms to help guide them through the necessary procedures. A writ of execution is a court order directing law enforcement, usually a sheriff, to seize and sell a debtor's non-exempt property to satisfy a money judgment. Issued after a final judgment is entered, this legal tool empowers officials to garnish bank accounts, seize vehicles, or sell assets to pay the creditor, to enforce a judgment for money or possession of property when a debtor refuses to pay voluntarily. The creditor requests the writ from the court clerk. Once issued, it is delivered to the sheriff or U.S. Marshal in federal cases for execution. Authorizes seizure of any non-exempt personal property. Targets specifically identified property. What can be seized? Bank accounts, vehicles, business assets, and in some cases, real estate. What cannot be seized? Exemptions. Exempt property varies by state, but often includes a portion of equity in a home, household furnishings, tools of the trade, and certain retirement funds. The enforcement process, levy and sale. The court clerk issues the writ once the appeal period has passed. The sheriff serves the writ and levies, physically takes control of the property. The sheriff can enter the premises, though they cannot break into a home without permission. The sheriff sells the property, often at a public auction known as a sheriff's sale. Proceeds are used to pay off the judgment, sheriff fees, and costs, with any remaining funds returned to the debtor. Debtors usually receive a notice of right to claim exemptions. Failing to file this in time can lead to losing protected property. A writ cannot be issued if a supersedes bond is posted during an appeal. If a debtor files for bankruptcy, the execution process is typically stayed. For a detailed understanding of how a writ works, see this Writ of Execution overview from the Latent Writ of Attachment law firm. Writ of attachment is a pre-judgment order to seize property to ensure it is available to satisfy a potential future judgment. A writ of attachment is a court order issued before a final judgment that authorizes law enforcement to seize or lend a defendant's property. It protects creditor interest by securing assets to satisfy potential debts, often forcing early settlements. Requirements typically include a contractual claim, specific monetary amount, and proof the plaintiff will likely win. To prevent debtors from hiding or transferring assets, bank accounts, real estate, personal property during pending litigation. Unlike a typical judgment lien, this attaches before the lawsuit ends, seizing funds from a third party, e.g. banks, recovering specific wrongfully held property. Writ of bodily attachment, a court order often used in contempt cases or child support non-compliance that directs law enforcement to physically bring an individual before the court. A creditor must show the claim is on a contract for a specific sum, and usually that the debtor is likely to hide or dispose of assets. The plaintiff files a request with the court. A hearing is held to determine if the attachment is warranted. which is often done with notice to the debtor, though ex parte, without notice, is possible in emergency situations. The plaintiff must typically file a bond, surety bond, to cover potential damages if the writ is found to be improper. If approved, a writ of attachment is issued. A sheriff or U.S. Marshal serves the writ to seize the property. If the writ is deemed improper, the creditor may be liable for damages. Defendants can object to the writ by motion. Ex parte writs are generally reserved for situations where the debtor is likely to hide assets. Procedures for writ of attachment. Essential guide to prejudgment. Seizure vary by jurisdiction and type of case. Specific laws, such as the 2025 Florida statutes for writs, control the specifics of the process.